everyone. As I said, happy October 1st. What we're going to be discussing today is what is elder law. So we're bringing this information to you every week, but who are we? What is an elder law attorney and what are we doing? And why are we talking about these topics? And so that's what we're going to explain today. I'm going to talk about the different kinds of things that an elder law attorney generally does and how they support their clients. So at its core, I like to think that elder law is the practice of estate planning attorneys in the end, and we are looking at the long-term care goals and needs. So will someone be aging in place if they choose to? What do we mean by that? How will they pay for it? And caring for themselves as well as possibly providing a legacy to pass on to their loved ones. And that's really what we're doing as elder law attorneys. We're talking about government benefits to provide for some care. We're talking about long-term care insurance. This is all very important as elder law attorneys. We also talk about wealth transfer at death. So traditional elder law may talk about preserving some assets for someone to receive Medicaid services, or not preserving any assets, but receiving Medicaid services for long-term care. But for others, it's talking about the purchase of long-term care insurance or self-insuring for your own level of care so that assets can be passed on. So as elder law attorneys, we need to be trust and estates attorneys. We need to know about tax issues, capital gains tax, income tax, estate tax. These are all things that are important, because if as an elder law attorney, I'm saying that you should transfer your home to another individual, be it your spouse or a loved one for any reason, or if it's to a trust for someone's benefit or for your own benefit, then I need to know what the tax implications are of making such a transfer to possibly advise you of what could go wrong or what the pros and cons are of that transfer. We're often saying to people, you don't get something for nothing. So if you're looking to transfer assets so that you can qualify for long-term care in a nursing home or for home care, well, then you're likely going to be giving something up in exchange for that protection. You may be giving up control. You may be giving up use. Whatever it may be, that's what we're here to do. We're here to explain what that means. There are a lot of individuals out in the world who could assist with filing a Medicaid application, a collection of documents and a filing. But what many people can't do legally is advise on these transfers and advise on the responsibility of the loved ones. So for example, if somebody comes to our office and they have assets that are above the Medicaid allowable level, and they have income above the Medicaid allowable level, and they have a spouse who has some assets and some income, then not only do we need to advise the person who needs the care as to how they can transfer assets, but we also need to be advising the spouse on what the potential exposure could be for the spouse's assets and income. And these are all things that are legal issues that need to be discussed. Certainly the transfer of assets and the tax implications on those transfers are also legal issues that need to be discussed. In addition to advising on these transfers and the tax issues, we are also advising clients as to the other documents that they need in order to keep themselves safe and healthy as they age and possibly as they have advancing needs. And that often comes in the way of discussing the kinds of documents that they might need. A power of attorney. Now, it's not just as simple as, do you need a power of attorney or don't you? But do you need a statutory gifts rider that allows your agent to create trusts for you? Do you need your agent to have specific powers to change beneficiaries or distributions on IRAs, to change the ownership of a life insurance policy? All these different things are individual powers that need to go into that document. And so an elder law attorney doesn't just say you need a power of attorney, but they tell you what items and they discuss with you what powers that agent should have and what powers that agent may need as you get older and need assistance of an agent under power of attorney. We also discuss healthcare proxies and living wills with clients. These are what we refer to as advance directives. They're documents that you sign in advance of needing them that state who will make your medical decisions if you cannot make them for yourself, and what type of decisions you would want that person to make on your behalf. Are you going to give them the power to make end-of-life decisions, artificial nutrition, hydration, and how are you directing them? These are documents that we're often talking to clients about and telling them, again, the pros and the cons of these types of documents. We also talk to clients about a last will and testament and possibly a trust. I see there's a question here, what is an asset management trust and is it advisable? That is a great question because the answer is it depends. An asset management trust can mean a lot of different things. It is a trust that holds your assets and they can be managed, but every trust is different. And the general idea of a trust depends on why you're creating it. Are you creating a trust for tax reasons? Are you creating a trust for long-term care reasons because you think you may need Medicaid down the line and you want to protect some of the assets? Are you creating a trust because you're worried that if you become incapacitated, you would like ease of administration? Or are you creating a trust because upon your death, you want to avoid the probate of your last will and testament? So an asset management trust is a trust that could refer to many different types of trusts, and it will all depend on what the terms are that go in the document. So that's something else that an elder law attorney can do. An elder law attorney can talk to you about what is important to you. So when we talk to clients, we're looking at who are the people you want to leave things behind to, if anyone. How important is it that you leave something behind for those individuals? How much control are you willing to give up? And then once we figure out what the goals are, we can then determine what type of trust may be good for you and what if it will achieve the goals that you've set forth. Not everybody needs a trust. We've said this for years at our firm, and we have to really go through with a client and advise them as to what they need in order to achieve their own goals in their situation. We often say that we are not just document drafters, we are counselors at law, and we advise clients. And so I was thinking about this day and what I was going to talk about when I talked about what elder law is. And part of that is I was thinking, what are the different areas that I need to be proficient in? What do I need to study up on? Well, I need to study up on Medicare and understand what Medicare is going to pay for. And when I see what the downfalls are for clients and what Medicare won't cover, well, then I have to be knowledgeable about what else can cover that gap. And that's when you get into what type of assets people have. So I have to understand how a brokerage account works, how an annuity works, how a retirement account works. I also need to understand the government benefits that are available to individuals. The biggest program that we deal with is the Medicaid managed long-term care program. So we need to understand not just what the laws are, but we also need to know how they are applied in each county where somebody may be applying for Medicaid, and also what changes are coming. You know, we're here on October 1st, and there's a big change in the Medicaid laws that went into effect today. And the change had to do with the transfer of assets and the subsequent, and if you can subsequently apply for home care community Medicaid. And transfers made prior to today were grandfathered in under the old law, which said that there is no look back period for transfer of assets. We're now in a middle time, a gray area between October 1st and January 1st, because we've passed the date by which the asset transfers are grandfathered in, but we've been told by the Department of Health that they're not going to assess a penalty period, and they're not going to look at back months for eligibility until January 1st. And so we need to be knowledgeable about what those laws are and then keep up on how they're being applied moving forward. Specifically, I want to go back to the conversation about the transfer of assets and the tax implications, because I think this is a really important thing to understand. If you have a home and you want to put it in an irrevocable trust, one that has the purpose of being a Medicaid asset protection trust, where you receive the right to live in the home for your life. If you were to rent it out, you could receive the income from that rental. And upon your death, it passes on to your loved ones, to whomever you've named. You cannot be the trustee of that trust for your home, but again, you keep the right to live in that home. Now, when you make the transfer, it's very important that that trust be drafted in a way that upon your death, your home receives what we call a step up in basis for capital gains. If you were to just give the property away during your lifetime, the person you give it away to would inherit that property from you or take that property from you, and they would own it at what we call the tax basis of how you purchased it. So I'm going to give you an example. We have someone who purchased a property for $10,000 in the 60s, and now it's worth $1 million. If you just give it away during your life, if your loved one that you gave it to sells it for $1 million, they're going to pay a big capital gains tax on the growth in that property. Whereas if they inherit it from you or through a properly drafted trust, they can inherit it at $1 million basis if that's what it's worth at your date of death. And then if they turn around and sell it for the same amount, there's not going to be a tax. So that is a very important thing, that you can't just transfer the property away. You really have to understand, again, what the implications are of making certain transfers and to whom you're making those transfers. In addition, and I mentioned this earlier, but I want to stress the importance of, if one spouse applies for Medicaid, it's very important to seek the assistance of an elder law attorney to understand what the implications are for the, we will call them the well spouse or the community spouse, the spouse who does not go on Medicaid and is not receiving the care. And you want to make sure that you're not putting that person in a position where Medicaid could seek money from them, contribution from them that they were not expecting to be sought. And that is something that most significantly applies in the 5 boroughs and less so on Long Island, but it's still something that a spouse needs to be aware of. I mentioned earlier that some people decide in the planning phases to purchase long-term care insurance. And I am not an insurance salesperson, but one of the things that I try to keep up on is what kind of insurance products are out there, so that I can refer clients to speak to somebody who is knowledgeable in that area and can provide information about that, so they can determine if that's something that they want to do. Long-term care insurance is an insurance that you pay a premium for, and then when you get to a point where you need assistance in the home, or you need assisted living, nursing home care, home health aides, after usually an elimination period, a period of time that they won't provide the care, which could be 30, 60, 90 days sometimes, then they'll kick in and they'll give you a daily amount. So for example, I have a client who can receive up to $275 a day of care. And by having that insurance, they don't have to go on Medicaid at this point, because they can have the care they need provided by that. So not everybody who is seeking elder law advice is going to end up on Medicaid. Some people are going to seek elder law advice and realize that the way that they are going to most efficiently age at home to solve their problems and meet their goals will be through the purchase of long-term care insurance. Yet for others, they don't purchase the long-term care insurance or plan for Medicaid, but maybe they know that they can self-insure with the other assets that they have. And so an elder law attorney often has to work very closely with a financial advisor, with an insurance advisor, with a tax advisor, to make sure that the individual client is taken care of. In addition to the estate planning and the government benefits that we often help clients with, as an elder law attorney, we also are usually handling guardianship matters. In this instance, I'm most specifically referring to the Mental Hygiene Law, Article 81 guardianships. This is guardianship over an incapacitated adult or adult who's in need of a guardian and consents to it, but shows that there's a need there for care or for assistance. And we're often involved in the courts in that regard. So there's an attorney who usually brings the petition. So perhaps daughter decides that mother needs some assistance and doesn't have the mental capacity to sign a power of attorney or a healthcare proxy. And so you have to bring a guardianship proceeding and ask for a person to be appointed guardian over that individual. There are court evaluators involved. They're usually attorneys, although not always, who are appointed to investigate to make sure that this person really does need a guardian. And then we work together, hopefully collaboratively, in order to come up with the least restrictive alternative for that person. So we want to create a situation that supports them and supports the needs they have, while also giving them the autonomy if they can take it, if they have the ability to take it, and only be awarding those powers to the guardian that are really necessary in order for this individual to be maintained safely. And so elder law often, if we can't have people at the point where they have a power of attorney who they trust, who's doing a good job, then sometimes we end up in this guardianship realm. We also often help people when it comes to special needs planning. So because elder law attorneys often deal with government benefits and applying for those government benefits, it goes hand in hand that we're also dealing with what happens if there is a person who has special needs and the client that I have wants to leave assets behind to that person. How do we make sure that that individual's inheritance is taken care of, and also that it doesn't jeopardize any of their government benefits? And again, this brings us back to the estate planning. We often have to create trusts for those individuals and make sure that they're properly protected. But again, also have the knowledge of those government benefits to know what that trust has to say in order for those assets to be protected. We're often advising people in that regard. And so again, I just want to summarize, an elder law attorney is very often an estate planning attorney who has the knowledge of an estate planning, trust and estates attorney, who's dealing with how somebody is going to be provided for the rest of their life and be maintained safely. And if they choose to, how they're going to save assets to pass on to their loved ones, be it their beneficiaries, the charities that they hold dear, or whatever it is. And I will open up to questions now if anybody has any. Oh, we have a raised hand. If possible, if you could type into the Q&A your question. I'm not sure if this person's able to type into the question and answer. Okay. Oh, the question is, do we work with people who are veterans? Yes, we do work with veterans. That's a good question. We do not apply for veterans benefits for individuals, but we often have veterans that we work with. And in some situations, a lot of times when we're talking to veterans, we're talking to them about the estate planning that might be required for them to apply for aid and attendance benefits. Aid and attendance is a pension that is available to veterans who are underneath a certain asset limit, and they can receive care or money towards their care if their unreimbursed medical expenses are such that it's higher than their income. And so we do often talk to clients about that and advise them in those ways, although we do not do the actual applications, but we set people up with people at the VA usually who can assist with that. Any additional questions? One other item I just want to add is that when we are creating wills or trusts for our clients, they are not always thinking about what's going to happen down the line. And so I think as an elder law attorney, what I enjoy is that when a client comes in and when we're advising them, and they may be young, they may be 50 years old, and this is the time that they're sitting down and they're doing their estate planning, and I may beg them to come back every 5 years because we want people to review their documents every 5 years, but they may not. And so as an elder law attorney, I'm always thinking about what would happen if this person didn't come back. Who are the beneficiaries they are leaving assets to, and how might we have to protect those beneficiaries? And how might I have to help my client protect themselves? And so oftentimes when we're creating documents as elder law attorneys that are for clients who don't necessarily realize that they're receiving this type of elder law advice, we're advising them to think forward to that time where them or maybe a loved one might need this other level of care, and how they can properly provide for that, even if they're so young they're not thinking that's the case. A perfect example is that oftentimes if we have two spouses leaving assets to each other, we may advise that they leave it to their spouse in a trust, because we can create a situation where if that surviving spouse needs care down the line, we can trigger that trust into being a protected trust for that individual. We can do so with other beneficiaries as well. So I think the good thing about being an elder law attorney, what I like about being an elder law attorney, is that I can assist whoever walks in the door, regardless of the amount of assets they have, their age, or their situation. We can help them make sure that they have the proper planning in place for themselves and their loved ones. Are there any other questions? I can wait a minute or so and see if anyone wants to chime in. Oh, we have another one. 1 second. Oh, the question is, why don't we apply for VA benefits? There's all sorts of rules with the VA about who can apply for veterans benefits and how attorneys can be compensated, and it's complicated. So it's actually better to do so with an expert from the VA, and so that's what we recommend people do. Although, you know, a lot of the information that people are using for those applications is similar to the information that they're gathering for community Medicaid applications, which we also assist with. But that is why we don't do the applications ourselves. And yes, next question is, do we have an office in New York City? And yes, we do. I'm sitting in our West Hampton office right now, but I was in our Manhattan office earlier today on 34th Street by 6th Avenue. Okay, I think that those are all the questions. I thank everyone for joining us today, and I hope that this was a nice overview and didn't make your head spin too much of all the different things that are running around in our heads every day and with all of our clients. And really the goal is to let you know that the elder law attorney isn't just for the elderly, it's for all sorts of individuals who are just trying to plan out their future in the most thoughtful way. So thank you for joining us, and I hope you all have a great day.